Good morning, friends. I'm Jyoti Dogra Sood. I'm an associate professor at the Indian Law Institute, New Delhi. My area of interest is criminal law. We are here today to discuss one of the modules of substantive criminal law. Friends, you'll agree with me, perhaps you'll agree with me, that killing of a human being, another human being, may be lawful or unlawful. And I'm using the word lawful very consciously and with responsibility because India is one of the countries which retains death penalty in its statute book. And that is why I use the word lawful. Because when killing of another human being is given as a part of punishment, the killing becomes lawful. As far as unlawful killing is concerned, it may be in different sections that killing falls under the Indian Penal Code. It could be culpable homicide amounting to murder. It could be culpable homicide not amounting to murder. It could fall within one of the general exceptions in Chapter 4, or it could be death by rash or negligent act. It is the first one, culpable homicide amounting to murder, which we are going to discuss in this module. So this module is totally dedicated to culpable homicide amounting to murder. The learning outcome of this module is to understand the general principles of criminal responsibility, which would be necessary to understand the criminal liability in cases of culpable homicide amounting to murder, to understand the intricacies of section 299 and 300 of the Indian Penal Code, which deals with culpable homicide not amounting to murder, to understand the relationship between section 299 and 300 of the Indian Penal Code, and also to understand and realize that the Indian Penal Code is very clear and precise, and the courts may not have to look at common law for all the cases that come before them. Having outlined the learning objectives that we have, let us now move to our module on culpable homicide amounting to murder. Now, as far as the scheme of Indian Penal Code is concerned, you have a section 299, I'll be calling it IPC for Indian Penal Code. 299 of IPC defines culpable homicide. Section 300 defines murder. So that means every offence which is a murder would definitely fall under 299, but everything which falls under 299 need not necessarily fall under 300 and be called murder, because it may be culpable homicide not amounting to murder. That means 299 is the genus and 300 is the species. Now, in an inquiry under section 299, death is the sine qua non. So there has to be a death, and then the inquiry proceeds further. Now, I would be dividing my module into various parts. My first job is to establish general principles of criminal responsibility, which would include contemporaneity principle, causation, objective and subjective liability. Once we have discussed this, then we move on to section 299 and 300, which are the main sections which deal with the subject under study, and then we go ahead with the conclusion. Now, friends, you must have heard of the Latin maxim which is very famous in criminal law, actus non facit reum nisi mensit reum. That means that the act alone does not make a man guilty unless it is accompanied by a guilty mind. So you have to have a guilty mind, plus there has to be a conduct. Now, there is a contemporaneity principle which is in operation, or a concurrence principle which we must understand, that the actus reus and mens rea must be contemporaneous. So, you know, mens rea is the mental blameworthiness, actus reus is the conduct element. Now, both of them must be contemporaneous. So, when you have the actus reus of an offence, it should be accompanied by mens rea and vice versa. Because it may happen that you want to kill somebody, so you have the mental blameworthiness, but you don't do an act and he gets killed. Doesn't mean that you get punished. It's only when your act accompanied by a mens rea you would be responsible. So you want to kill a person, but you've been thinking about killing a person, but you accidentally kill him. You would not be liable for the offense of murder because there was a problem with the contemporaneity. There was a very old case, Emperor versus Khandu, which you must go through. What happened in this case was, and that will make you understand the contemporaneity principle. What happened in this case was that this man hit another man, the defendant hit another man with a stick. He fell unconscious, believing him to be dead. Okay, he put the house on fire. Now you must understand, when there was mens rea of killing, the actus reus was not there because the act was not enough to kill the person. When he died because of the fire in the hut, the mental blameworthiness was not there. And the court held that, because of lack of contemporaneity, this man was not held liable for murder. But in an English case, Thabo, these people, they want to kill this person, hit him hit him on the head. He falls unconscious. They want to show it, like the Khandu case, want to show it off as an accident, push him down the cliff. It was then declared that he died because of the cold, not because of the initial hitting. So again, the same problem of contemporaneity. But the courts decided that since it was a preconceived plan, so this man was held liable for murder. Now we must understand that we would have to deal with the contemporaneity principle, and commentators, legal scholars, criminal law scholars have come up with different ways of dealing with contemporaneity. One is the Thabo case, preconceived plan. It could be a same transaction, so Khandu, if same transaction principle was used, the results would have been different. Or some commentators have talked about a moral congruence. So if the acts have the same moral congruence, the contemporaneity principle would be satisfied. I wanted to flag this issue because it becomes very important, because probably we would not like a judgment like Khandu, and there are others like Palani Gaundan, and so we must settle these principles before we move ahead. Now I have been calling actus reus and mens rea, so let's settle that also. Now you must understand that the Indian Penal Code, there is nothing like mens rea. The word mens rea doesn't figure there. And some commentators feel, why do you import something of a common law into the Indian Penal Code? Indian Penal Code, the word mens rea is not there, but there are words like intentionally, knowingly, dishonestly, fraudulently, which talks about the mental blameworthiness. So rather than using the word mens rea, it would be safer for us in India, in the Indian Penal Code, that we use the word mental element, the fault element. So we could safely use the word fault element. And the actus reus is the physical element or the conduct element. Now what is actus reus? Actus reus is, Kenny says, that result of human conduct which the law seeks to prohibit. When you look at 299 and 300, whoever does an act which kills, when death is caused by an act, these kind of phrases are used. Okay, I'm not using the exact language of the text, but these are the ones which connote the actus reus. Then you have section 32, section 33, section 36, section 39, which talks about actus reus. 32 would say that it's not only the act, it's also the illegal omission. 33 would tell you it's not a single act, it's series of acts. So the same transaction approach that I was talking in Khandu, maybe if we look into section 33, perhaps we may find an answer there. Section 36 says that an offence could be partly by an act or partly by an omission. So it could be a positive act or a omission, that both gets covered. Now 39 is very important because it talks about voluntarily. Okay, so the actus reus would, the physical element, the voluntariness is very necessary. So you understand that now I am saying physical element and a fault element for actus reus and mens rea. Now for a physical element and a fault element, voluntariness is very, very essential, because see, if an insane person fires a gun and somebody gets killed, that's not a voluntary act. If you go to child to kill somebody, that's not a voluntary act. So that actus reus, the physical element and the fault element doesn't get satisfied. Okay, so these are some of the things that we'll have to keep in mind. Now coming to the fault element, the mens rea, the fault elements, which I'm using the word fault elements. As far as killing is concerned, killing or death of a person is concerned, the fault elements used are intention, knowledge, rashness and negligence. Now intention is very clear. Intention is when you have a desire to do something, you conceive of something, you want the consequence to follow. That is a very higher degree of mental blameworthiness, the highest kind of fault element that you have. Second is knowledge. Now there's a very thin dividing line between intention and knowledge, but nevertheless it is there. A man has three faculties: emotional, volition and cognition. Now knowledge is the mental cognition. The person may not desire it, but then there is a mental awareness which could be attributed to that person, and that shows the mind of a man. Now recklessness would be a wrongful disregard of a foreseen risk. In Indian Penal Code, it is death by rash or negligent act. So rashness and negligence, rashness, if you think of it in terms of recklessness, rashness and negligence have been clubbed together. So that's open for debate and we'll not get there. Negligence is actually a blank state of mind where there is, there's lack of due care and attention. Okay. So having said this, now your physical element is clear, I hope. Your fault element is clear. Your contemporaneous principle, concurrence principle is clear, that you need to have a physical element and you need to have a fault element, and there has to be contemporaneity, there has to be concurrence between these two elements to impute criminal liability. Now friends, I have actually told you the physical elements and the fault element which would necessarily be required for an inquiry for culpable homicide amounting to murder. Okay. So I have told you the physical elements that should be present where they figure in IPC, and I have given you a sense of the fault elements that you would be looking for in terms of culpability. This finishes the first part of my introduction. We would be moving to the second part where very fundamental principles would be discussed, that of causation and of objective and subjective liability.